Welcome to Diagnosing Health Care, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare. While these issues may seem like hurdles, we'll also look at the business opportunities and solutions that exist. Diagnosing Healthcare is brought to you by the healthcare lawyers at Epstein Becker Green, a leading law firm that has more than 40 years' experience serving clients in the healthcare industry nationwide.
Today on Diagnosing Healthcare, we will discuss how the Supreme Court's decision in Dobbs versus Jackson Women's Health Organization has impacted pharmacies and pharmacists, including patient access to certain reproductive health or abortion-inducing medications, dispensing of drugs, and scope of professional practice requirements. Hello and welcome. I'm your host, Jessika Tuazon. I'm an attorney in Epstein Becker Green's healthcare and life sciences practice based out of our Los Angeles office. In June 2022, the Supreme Court issued a decision in Dobbs versus Jackson Women's Health Organization that overturned Roe versus Wade's long-standing constitutional protections for abortion access and deferred the regulation of abortion to states. Although most people probably believe that the majority of abortions are procedures that take place in clinics across the country, in the United States, approximately 54% of all abortions take place following a patient's ingestion of certain FDA-approved prescription drugs. In the aftermath of the Dobbs decision, important questions have emerged about the current legal and regulatory landscape surrounding patient access to drugs that have historically been used to induce abortions, and how healthcare providers, pharmacies and their staff, and other entities in the pharmaceutical supply chain must navigate these new restrictions. Today, we will discuss various legal issues that pharmacies and pharmacists face in the wake of the Dobbs decision, and how these issues impact how pharmacies meet patient needs and deliver medications in compliance with applicable laws, as well as pharmacists' rights to dispense or not dispense medications pursuant to valid prescriptions. If you like what you hear today, please subscribe to the show. Diagnosing Healthcare is available wherever you get your podcasts. Joining our discussion today are Delia Deschaine and Spreeha Choudhury. Delia is a healthcare and life sciences partner in EBG's Washington, D.C. office, who focuses her practice on counseling pharmaceutical and biotechnology clients on a broad range of FDA and controlled substance regulatory matters. She also advises clients on conducting internal investigations and defending against government investigations and litigation. Welcome, Delia.
Thank you, Jessica.
Also joining our discussion today is Spreeha Choudhury. Spreeha is also an attorney in our Washington, D.C. office. She advises clients on regulatory issues relating to pharmaceutical development and testing, pharmacy operations, and matters concerning telehealth. Spreeha also holds a Doctor of Pharmacy degree. Welcome, Spreeha.
Thanks, Jessica. Happy to be here.
Delia and Spreeha, thank you so much for joining today's podcast. Before we dive into our discussion on pharmacy and pharmacist considerations following the Dobbs decision, I thought it might be helpful to provide some context for any listeners who may be new to these topics. Throughout this podcast, we will be discussing patient access to certain abortion-inducing drugs. When using this term, we are referring to certain types of drugs that are prescribed by healthcare professionals, which, when taken by a patient, are intended to terminate a pregnancy, or what we may refer to as an abortion, including to facilitate the passage of non-viable pregnancy tissue, such as for miscarriages or stillbirths. One drug that is used for medical abortions has been approved by the U.S. Food and Drug Administration, or FDA, specifically for terminating pregnancies. Other medications are lawfully prescribed off-label for this purpose. One drug that is frequently at the center of abortion-related discourse is mifeprex, or the generic form mifepristone. In 2000, the FDA determined that mifeprex, when used together with misoprostol, is safe and effective when used to terminate a pregnancy in accordance with the approved labeling. Mifepristone is subject to a risk evaluation and mitigation strategy, or what we refer to as REMS, and FDA may put a REMS in place for certain drugs with serious safety concerns and may require certain information to be communicated to and/or required activities to be undertaken by one or more participants who prescribe, dispense, or take the medication, including healthcare providers, pharmacists, and patients. During the COVID-19 pandemic, the FDA is exercising enforcement discretion regarding the in-person dispensing requirement of the REMS, allowing the medication to be prescribed via telehealth. FDA has also announced that it must permanently remove this requirement from the REMS and replace it with a pharmacy certification requirement. However, that change has not yet been made final. Since its approval in 2000, states have made efforts to restrict access to the drug in similar or more restrictive ways than the federal REMS, and such efforts are likely to intensify in the coming months. Shortly after the Dobbs decision was made public, Attorney General Merrick Garland issued a statement making clear that the FDA has approved the use of the medication mifepristone and that states may not ban mifepristone based on a disagreement with the FDA's expert judgment about its safety and efficacy. These comments have renewed debates about whether the FDA's decision to approve mifepristone preempts state laws that aim to ban or otherwise prevent access to the drug. To date, however, few states have attempted to ban FDA approved drugs, so there's not much precedence to look to. Delia, can you expand a bit more about the potential preemptive effect of the FDA's drug approval and whether states may have authority to restrict patient access to FDA approved drugs because they disagree with FDA's judgment about the drug's safety and efficacy?
FDA's approval of a drug means that the drug may be lawfully marketed in interstate commerce. And federal law is deemed the supreme law of the land. Therefore, there is an argument that states may not limit or restrict the sale or even the prescription of an FDA approved drug that is sold in interstate commerce. And there are, in fact, cases where courts have held as much. There's also a recognition, however, that states, as a general matter, have the authority to regulate the practice of medicine. And this would presumably include regulating which drugs can be made, sold, distributed, dispensed, prescribed, or even used in the state. When thinking about how to resolve these tensions in the context of federal preemption, courts will typically look to a few things. One, whether Congress has directly spoken to the issue. In other words, whether Congress has enacted language in the governing statute that expressly preempts the state's law. And if not, whether Congress has impliedly preempted the state law at issue through rendering compliance with both laws impossible or rendering the state law an obstacle to implementation of the federal law. In the context of prescription drug regulation, Congress has not expressly preempted all state laws that regulate prescription drugs. It has done so, though, in the context of over-the-counter medication. And that matters for purposes of states' regulations of emergency contraception that is available OTC, such as Plan B. However, as you mentioned, Jessica, the abortifacients that are used in medication-induced abortion are not OTC drugs. They are prescription drugs. So courts have really had to look to whether compliance with the federal and state law is in fact possible, and even if so, whether the state law stands as an obstacle to implementation of the federal law. And thinking about impossibility preemption, there actually is some U.S. Supreme Court jurisprudence that may be instructive. The court has considered on several occasions whether a state product liability law is preempted when it is applied to a prescription drug manufacturer. The court considered this issue with respect to brand drug manufacturers in Pliva v. Mensing, and later with respect to generic drug manufacturers in Mutual Pharmacy Company versus Bartlett. And it was in that latter case that the court held that the Federal Food, Drug, and Cosmetic Act does preempt a state law that requires a drug manufacturer to add increased warnings to its product's labels. The court found those state laws preempted because the federal law requires that a generic drug manufacturer market its product with labeling that is identical to its brand counterpart. Therefore, the court found that it would be impossible for the generic drug manufacturer to market its product in accordance with the state labeling law and federal law. In so doing, the court considered whether the manufacturer could simply comply by not selling its drug into the state. And the court rejected that argument, holding that it was incompatible with its preemption jurisprudence. The court recognized that its preemption cases presume that an actor seeking to satisfy both his federal and state law obligations is not required to cease acting altogether in order to avoid liability. Indeed, if the option of ceasing to act defeated a claim of impossibility, the court said, impossibility preemption would be all but meaningless. Therefore, there is a strong argument that the law really does favor a finding of preemption of state abortion law restrictions, especially when a state's law goes so far as to ban the sale or prescribing of the FDA-approved drug for its FDA-approved use. And that's the situation that we're finding ourselves in the wake of Dobbs. There are other cases that are relevant here as well, some of which have arisen in the context of controlled substances regulation, i.e. opioid drug products. And it's important to note that in that context, the case against federal preemption is actually much stronger because Congress has said in the Controlled Substances Act that states may more stringently regulate controlled substances than the federal law. Regardless, even in that context, courts have declined to recognize that states have an unfettered right to regulate how a drug may be prescribed or dispensed, consistent with the FDA's approved label for the drug. Therefore, I think we're likely to see cases arise where courts are being asked to decide how far a state can go in limiting access to FDA-approved abortion-inducing drugs. And some courts may be reluctant to recognize that states have an unfettered blanket authority to restrict access to these medications.
Regardless of whether or not the FDA could prevail on a preemption theory, I think we would be remiss if we did not talk a little bit about how these new restrictive state laws may impact pharmacies and other entities in the distribution chain. Pharmacies and other companies in the supply chain may be impacted by any state legislation intended to restrict access to certain abortion inducing medications. How does this impact a pharmacy's role in dispensing of these drugs, including shipping of medications to patients in states that may have prohibitions on abortion? Spreeha, do you have any thoughts on that?
Sure, I'm happy to address this question. I think it's really important to discuss the mifepristone risk evaluation and mitigation strategies, also known as REMS, and how they've changed in the last year. Prior to 2021, under the mifepristone REMS, the drug could only be ordered, prescribed, and dispensed by certified prescribers. To become a certified prescriber, healthcare providers were required to complete a prescriber agreement form prior to prescribing and dispensing mifepristone. A certified prescriber must be able to determine gestational age, diagnose ectopic pregnancies, which generally requires an ultrasound, and intervene if the abortion was incomplete or if there was severe bleeding. The REMS also required mifepristone to be dispensed in person in clinics, doctors' offices, or in hospitals under the supervision of the certified prescriber. Patients were required to sign a patient agreement form, and these restrictions essentially barred pharmacies and pharmacists from dispensing mifepristone at all. Due to COVID-19 and the ensuing public health emergency, the FDA issued a letter in April of 2021, which stated that it would be using its enforcement discretion and no longer enforce the in-person dispensing requirement for mifepristone. This opened up the door for pharmacies to dispense mifepristone, including by mail order. While prescribers still need to be certified in order to prescribe mifepristone, the FDA has also said that it does not intend to take enforcement action against sponsors or others for accommodations made during laboratory testing or imaging study requirements imposed under the REMS during the public health emergency, provided that such accommodations were made based on the judgment of a healthcare professional. Finally, in December of 2021, the FDA decided to permanently eliminate the in-person dispensing requirement in the mifepristone REMS, which would allow pharmacies to continue dispensing mifepristone even after the public health emergency ends. However, such pharmacies would need to become certified pharmacies. The pathway to the certification of pharmacies has not yet been established, and the change to eliminate the in-person dispensing requirement will not be made final until the FDA approves supplements filed by the manufacturers of mifepristone, which are Danco and GenBioPro. The sponsors need to request that change. Danco submitted its pharmacy certification plan to the FDA in June of 2022, and the FDA's goal is to review the supplements within 180 days of filing, meaning that the FDA could approve the new REMS later this year, allowing pharmacists to become certified and continue dispensing mifepristone as they have been doing throughout the public health emergency. To complicate matters further, several states have laws that codify the in-person dispensing requirement for mifepristone and other abortion-inducing drugs, which may block pharmacies in those states from dispensing these medications now and even later, even if they are REMS certified. Some states also have aiding and abetting laws, which arguably could prohibit pharmacists from dispensing abortion-inducing drugs, and may even impose criminal penalties on pharmacists for dispensing abortion-inducing drugs. In some of these states, the definition of abortion is so broad that they could be interpreted to prohibit pharmacists from even dispensing Plan B. As Delia mentioned earlier, Plan B is a drug which delays ovulation to help prevent fertilization of an egg and is available over the counter without a prescription. Plan B is unique in the sense that access to contraception remains protected under the U.S. Constitution. It's available OTC, which limits how states can regulate it.
Delia, are there any other legal issues that pharmacies or other members of the supply chain may want to consider?
Sure. So, as Spreeha mentioned, the potential for accessory liability under state criminal and civil abortion laws is an important issue that all supply chain members should be reasonably considering in the wake of Dobbs. That analysis has to factor in, however, that all of the medications that are at issue here may be prescribed on or off label for reasons completely unrelated to abortion. For example, misoprostol is indicated for use in treating stomach ulcers, and mifepristone is approved by FDA for treating Cushing's syndrome. Methotrexate is approved for treating rheumatoid arthritis and is also used in cancer treatment. This muddies the waters a bit when determining whether an entity in the supply chain can in fact be held civilly or criminally liable as an accessory under various state abortion laws. Another important issue that supply chain members should consider is the potential for these medications to be diverted and sold into illicit channels. We've already seen news outlets reporting an uptick in the supply of abortion-inducing drugs through illegal channels. So at the same time that we're seeing the number of legal abortions decline in the US, we're seeing an increase in the number of illegal abortions. This matters for entities in the supply chain who are maintaining supply chain integrity programs, because in addition to lost product, diversion can also translate into the inadvertent introduction of counterfeit or illegitimate product into the US marketplace. The Federal Drug Supply Chain Security Act requires manufacturers, distributors, dispensers, and other entities to take certain actions to ensure the legitimacy of the medications they supply in the US. Therefore, suppliers and pharmacies may want to consider whether any changes to their federal DSCSA programs are warranted due to the increased potential for diversion of these medications.
Great. Thanks, Delia. So at this point in the podcast, we've talked a lot about the impact of Dobbs on pharmacies and other members of the supply chain, but we haven't yet talked in detail about the impact on pharmacies and their scope of professional practice. Since the Dobbs decision was issued, there have been reports of pharmacists who have refused to fill prescriptions if the prescribed drug could harm a pregnancy. Instances like this likely prompted the Department of Health and Human Services, or HHS, to issue guidance stating that pharmacies may not discriminate against customers, including with regard to supplying medications, making determinations regarding the suitability of a prescribed medication for a patient, or advising patients about medications and how to take them. This has raised questions around the validity and enforceability of internal company policies that may allow pharmacists to use professional discretion to deny medication to individuals they suspect are trying to skirt state laws restricting abortion, and has also put a spotlight on state professional practice laws. Delia and Spreeha, what are pharmacists permitted to do and prohibited from doing in the context of dispensing drugs? And do state laws afford pharmacists religious or moral discretion?
So pharmacists can refuse to dispense abortion-inducing drugs under both federal and state laws. Under federal law, the Church Amendments, the Weldon Amendment, and Public Health Service Act, Section 245, protect healthcare providers' conscience rights. However, not all of these laws apply to pharmacists or pharmacies. The Church Amendments are potentially the most applicable. However, those only apply to entities that receive certain federal funding. It's also important to notice that the HHS guidance states that pharmacies and pharmacists may not discriminate against pharmacy customers based on race, color, national origin, sex, age, or disability when making their recommendations regarding medications, supplying medications, or counseling their patients. The guidance specifically states that discrimination against pregnant people on the basis of their pregnancy is considered a sex discrimination. Under some state laws, pharmacists can refuse to fill an abortion-inducing medication prescription, but they must provide some other type of patient care. Some states don't require pharmacists to take any additional actions after refusing to fill a prescription. There are certainly tensions between state and federal laws regarding what pharmacists can and cannot do. Currently, the DOJ has a reproductive rights task force monitoring state and local actions which may infringe on federal protections of reproductive care. Among other things, the task force will be monitoring state and local actions which seek to impose criminal or civil liability on federal employees providing reproductive care that is authorized by federal law.
Thank you, Spreeha. That was very informative. We've covered a lot of information in today's discussion. Although we know the Dobbs decision will have a profound impact on the drug industry and patient access to critical and sometimes life-saving drugs, it remains to be seen how federal and state laws enabling and restricting access to these drugs will continue to evolve over time. In the meantime, what is one piece of advice that each of you would give to pharmacies and pharmacists that are grappling with all of these various issues?
I would advise pharmacies and pharmacists to be thoughtful in how they approach these issues and try to avoid knee-jerk reactions that often accompany operating in a highly uncertain legal environment. While the legal risks and penalties for noncompliance with state abortion laws are steep, so are the legal and practical risks associated with restricting access to medications that may in some cases be life-saving.
For me, I'd say that if there are any pharmacists listening, remember that as a pharmacist, you are an accessible healthcare provider. So patients will likely ask you questions about abortion access. Being well-versed in these issues will help you answer those questions accurately and objectively.
Well, I think that brings us to the end of our podcast. So thank you, Delia and Spreeha, so much for taking the time to discuss drug access post-Dobbs. And thank you to all of our listeners. I'm your host, Jessika Tuazon. If you like what you've heard today, please don't forget to subscribe. Diagnosing Health Care is available wherever you get your podcasts.
Thank you for listening to Diagnosing Health Care. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. The Employment Law This Week and Diagnosing Healthcare podcasts are presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of the legal services to be performed is greater than the quality of legal services performed by other lawyers.